Hello, and thank you for joining me here on YouTube. My name is Will Hannosh. I'm an attorney here in San Diego, California. My office is right here in the heart of the Mission Valley area. I've been practicing law for close to 17 years. The areas of law that I've practiced in are family law and also civil litigation. I also do guardianships as well as step-parent adoptions. The topic that I want to talk about today is why family courts in California require parties who are going through a divorce or legal separation to file financial declarations. If you are in family court or you have any exposure to family court, you'll see that financial declarations are also referred to as PDODs. PDOD stands for Preliminary Declaration of Disclosures. And the reason why family courts require parties to file financial statements or PDODs is simply because it's required by the law. It's required by Family Code 2100, and then the code sections that follow 2100. I'm not going to bore you with all the statutes and the code sections because I don't have that much time, and I know you don't either. But I will say this, that in California, Family Code Section 2100 tells us that it's the policy of the state to, quote, reduce the adversarial nature of marital dissolution, end quote. How do courts do that? Courts simply do that by pushing the parties to file their financial statements in a way that's clear, in a way that's accurate, in a way that's honest, and within a certain time frame too. So I often get this response or statement from my clients, which is, I have nothing to my name. I'm indigent, or I really don't have a lot. I don't have any savings. I don't have retirement. Why should I file financial declarations? Well, the answer is simply twofold. Number one, the law says you have to. So the other party is going to expect you to file and exchange your PDODs with them. And then number two, you're not going to get a judgment for divorce or legal separation until you do that. And this is mutual, like both parties, both divorcing parties or parties going through legal separation must file and exchange their financial declarations. And then the same statute, Family Code 2100, you can look it up, tells us, this is at subsection C, it says that parties in a divorce or legal separation must make, quote, a full and accurate disclosure of all assets and liabilities, end quote. And this is, in my opinion, how divorces and legal separations become delayed. They become delayed because oftentimes one party, or maybe both, are not going to be interested or keen on disclosing everything that's in their name. People, for the most part, want to remain private when it comes to their financial station in life. And most people are not interested in disclosing their monthly income, what's in their retirement, how much debt they might have, or how much they've invested in, cryptocurrency and that sort of thing. And so people are not naturally inclined to want to give this information up in their financial declarations or preliminary declarations of disclosure. And that's where the help of a good attorney who's experienced in family law, such as myself, could come in and assist with that. The thing is that, divorce cases can linger for months, unfortunately years. Now, barring any other type of reasons for conflict and disputes, I find that a party's responsibility in giving this information is sometimes misconstrued by the client themselves, and it can lead to a lot of problems. And then, of course, each party, even though each party has a responsibility to forward this information and file it with the court, they also have a right to see what the other spouse has and doesn't have, how much he or she makes per month, how much he or she may be making in overtime, how much he or she may have saved. Does he or she have some other private account that he or she never disclosed to you? These are all reasons why the filing and the exchange of the PDODs can cause your divorce or legal separation case to just linger and linger and linger. And when that happens, there's a couple things that can take place. This is quite normal, quite expected, actually. After a while, the family court's going to get impatient. They're going to turn to you or to the other party, and they're going to say, Mr. X, you filed your response to this divorce 17 months ago, and I still haven't seen your PDODs. That's not good. Can a court sanction you for not filing your PDODs? Absolutely, they can. Do they do it often? Not really, but the court has the power to sanction you under Family Code 290 and all the other powers that it has. So you really want to make sure that when you're filing and exchanging your PDODs, that you're doing it as the code section requires, that there's a full and accurate disclosure of all assets and liabilities. And that's very important. Why is that important? Well, first of all, you don't ever want to be the party in a divorce or legal separation who held back on an asset or certain income or perhaps secondary income. And then months down the road, it's found out that you just never disclosed this item or this asset or this property. So one reason why divorces can be prolonged is because a party is just not willing to cough up that important financial information. The other reason why a divorce can be prolonged, this is the same for legal separations too, is because the party that has a right to see that financial information that belongs to the other spouse is also, like the courts, going to get impatient with waiting. So what does that party do? They resort to the use of discovery. What does discovery mean? Well, discovery is just a fancy legal term for you have information and I need it. And so people will resort to using discovery because that other party just simply isn't giving a full and accurate disclosure of all assets and liabilities or their income on their PDODs. And so the other party that's entitled to that information is going to tell their attorney, hey, just do some discovery. I want to find out what that person's true monthly income is, what their business interests are. Does he or she really have ownership to this company or this business entity or this asset? So remember, in a divorce or legal separation, you always have the right to do discovery. You have the right to ask your attorney to do discovery. Will it become more expensive for you? For sure it will. And that's why you want to have an honest talk with your attorney and make sure that your attorney is only going to file or submit discovery if you give them the consent or permission to do so. And not to digress too much, but there are attorneys that will just, issue discovery to the other side and not even check with their client about it. Here at Law Office of William Hannosh, we don't do that. I always ask my client for their written consent to conduct discovery, no matter how important it may be, no matter how necessary it may be. And I always get that consent from the client in writing, and they do have an understanding that it's going to cost them more. Now, what are the documents that you need to fill out, complete, sign, and exchange and hand over to the other side? I'll just rifle through them really quick. Number one, you got to do the income and expense declaration. This is a 4-page document. The form number, in case you'd like to know, is FL 150. This document is absolutely needed for divorce or legal separation. It basically gives the court a snapshot of what your monthly income is. If you tell me that you are on fixed income, that you only get Social Security, Perhaps you're getting a stipend of some sort or retirement, and that's all you get. Do you still have to file this form? Yes, you do. The courts expect it. The law says you do. And then the other party in your divorce or legal separation is going to expect it as well. So that's something that needs to be filed. On a side note, the FL 150 must be filed if you, the party, are filing a motion with the court or you're making a request with the court that has anything to do with the dollar sign. If you're asking for attorney fees, you need to file one of these out. On page 3 of the FL 150, it will ask you, how much have you paid in attorney fees? How much have you incurred? How much do you owe still, perhaps? And so the FL 150 is used for just that. Is it only for motions for attorney fees? No. If you're asking for child support, you need to fill out one of these and file it with the court and serve it on the other side. If you're asking for spousal support, you need to do the same. If you're asking for anything that has to do with money, essentially, the FL 150 must be filed, must be served on the other side. The next form I'm going to move on to is FL 142. It's a schedule of assets and debts. This one, it gives the court a view of what your complete worth is as far as financially, to be sure. It will ask, what are your assets? Do you have any real property? Do you have any cars? Do you have any bank accounts? Do you have any savings accounts? Do you have retirement, pension, deferred compensation plans? It will also ask you if you have any debts. If you have debts, do you have student loan debt? You'll notice that student loan debt it has its own field on the schedule of assets and debts. I think one reason for that is because when you incur student loan debt, even during the marriage, as long as community property income was not used to incur that debt, then the party that incurred the debt is going to be on the hook for repaying that student loan debt. But anyway, I don't want to digress. I will make a video in the future that goes through how to fill out and complete these forms properly. The schedule of assets and debts is important because it gives the other party really an understanding of what your worth is. And really, to be frank, it's your opportunity to take a complete and full inventory of what your financial position is as far as debts, ownership of any business interests, and savings, retirement. Cryptocurrency is involved, of course. If you have that, you must list it. Question I get often is, if I have separate property, it's property that I inherited or was gifted to me from a relative or parents, do I need to list it on the FL 142, Schedule of Assets and Debts? The answer to that is yes. You need to list every asset, every debt, every property. Anything that's in your name basically must be listed there. I'll give you an example. If you have retirement, is it enough for you to just go and write the words retirement under the field that asks for retirement? And the answer to that is no. You got to list the true legal name of the retirement administrator or the company managing your retirement. And you need to list how much was in that retirement account on the date of your separation. Another form that we use in family law, before I move on to the next form, I need to also inform you that the FL 142 Schedule of Assets and Debts is not filed with the court. It's not filed with the court. It is served on the other side, but not filed with the court. And you still want to be the party that gives a full and accurate disclosure of all assets and liabilities when you file the FL 142. Why? Because simply it is a document that you're signing under oath, or you're signing it under penalty of perjury. That means it can be used against you in the future in any court of law. So it's with this form, it's really with all the forms, but especially with this form, that you want to be as forthcoming and complete and accurate and as comprehensive as you can in the providing of information as possible. The other two forms, it's really one form. It's called the property declaration. It's a FL 160. The FL 160 is the one form that can take on one of two names. It can be considered the community property declaration, depending on the box you check. That's on page 1 of the FL 160. So if you're going to use a property declaration, you're going to check off, you can check off the box for community property, and then you recycle the document or reuse the document and check off the box for separate property. If you're going to use this form, do both. There's no point in using this form just to do your community property. The court would still want you to file a document. Even if you have no separate property, in my opinion, it's a good idea and advised to file a separate property declaration using the same FL 160 and just state zeros, state none, and still file it with the court. Then there's another document called Declaration of Disclosure. It's basically a document that basically tells the other party that you've been full and accurate and forthcoming in all the information, that you're not holding anything back, essentially. And then there's another document, which it's a document that shows to the court that you have served or provided to the other side all of these documents, the PDODs. That document is called FL 141. It's called Declaration of Service regarding Declaration of Disclosure. It's a long name, so you may want to remember it as FL 141. Why is FL 141 so important? And in my experience, I've seen many divorces or legal separations prolonged or delayed for this reason. A party will file and exchange all their financial declarations, their PDODs, but then they'll forget to complete and sign and file this one document, the FL 141, and then the court could just be waiting for weeks, sometimes months, and then you go to a hearing and then the court asks you, sir or ma'am, where's your FL 141? I've been waiting for you to file this so that I can move you to the next level to get your divorce or legal separation finished. You gotta remember to file and serve, and you need to file the FL 141 so that the court can give you, at least here in San Diego County, the judges won't give you a mandatory settlement conference until you file the FL 141. What I'm going to do in the future is I'm going to put together some other videos that explains to you in a clear and succinct way, as much as possible at least, because I know I can be long-winded, how to file, how to complete, how to finish, how to report your information on all of these documents. We'll do a video for the FL 150, one for FL 142, and then FL 160 as well. And so we'll go through that. I'm not going to spend that time doing that today. We won't go through that kind of detail today. I just wanted to give you a snapshot of what your responsibilities are as far as what needs to be filed with the court, what you need to serve, hand over to the other side, and really what your rights are as far as what you need to be given as far as information concerning the other spouse's financial station in life. This is really, really important. I know that the state of California takes these things very, very seriously. As a matter of fact, we take it so seriously that there's even a corporations code section that kind of bolsters the need to file all this financial information and provide it to the other side in a way that's full, comprehensive, accurate, and honest. If you want to talk to me, make an appointment with me so I can sit with you so we can go over your PDODs. Our paralegals can even help complete your PDODs, and I'll take a look at it to make sure it was done correctly. Please just give me a call at the phone number down there. You can even email me. My phone number and email are down there. And we'd be happy to sit with you to help you with the PDODs, because there really isn't any point in you waiting, having your case linger or delayed when you can just call us. We'll help you with the paperwork, make sure it's done right. You can file it yourself if you'd like, or we're happy to represent you as well. So happy to talk with you, happy to meet with you. Wish you the best in what you're going through. And please don't forget us. We're here to help. We've helped hundreds of clients, and we'd love to help you if you're in that if you have that need today. So thanks for hearing me out, and thanks for meeting me here on YouTube.